Welcome to the first episode of Leading on Risk, a new Locked in Professional and Executive Risk video series, in which we'll share insights on the risk topics that matter most to your business. My name is Sarah Downey, and I'm Head of Operations for our Professional and Executive Risk team. And I'm joined today by my colleagues Andrea Lieberman, Head of Professional and Executive Risk Claims, and Scott Behrens, Director of Government Relations. The second Trump administration has promised to take a more hands-off approach to regulation, and in just 3 months, they've already made a lot of changes. Today, we'll talk about what the administration has been doing, what businesses can expect going forward, and how organizations and senior leaders can manage key risks, including management liability. Let's jump right in and get started. Scott, to get us started, how is the regulatory environment changing?
In incredible ways. It's only been a little over 100 days, and we've seen quite a shift from the Biden administration to the Trump administration. As you mentioned, President Trump campaigned on reducing regulations and limiting enforcement, making it a little bit more business friendly, and he's started doing that very rapidly. We've seen everything from cuts to personnel, as well as administrative agencies through DOJ. We've seen reorganizations of agencies, and we've seen the Trump administration change their litigation positions in court from the Biden administration.
So zooming in a little bit on that, what key actions have we seen the administration and various agencies take so far?
Well, let's start with the executive orders. There have been quite a few of them. A lot of the executive orders are out there that they provide a framework for the regulators to understand the policy of the administration and encourage the regulators to issue guidance and maybe even change their enforcement policies. They also make changes to how the government works, acts as an employer, as a buyer of services and goods as well.
I think a really good example of governing by executive order, and that's something that I think everyone is very familiar with from the news, is the DEI executive orders related to termination of federal DEI programs and dissolution of federal offices related to DEI. There's various components to these various executive orders, but they're eliminating affirmative action for federal contracts or halting enforcement by the DOL, the federal contract compliance, or ordering agencies to issue guidance, and they're specifically going after, I'm sure we've all heard about law firms and large educational institutions.
Yeah, and then there's the recent EO dealing with disparate impact claims.
Correct. Yeah, correct. And disparate impact is, not direct discrimination in terms of discriminatory intent, but it is an act that's undertaken that has a disparate impact on a group of protected persons. And so the Trump administration has now said, we're not going to enforce that on the federal level, but states can still enforce it and private plaintiffs can still pursue those types of actions.
Scott, earlier you mentioned changes to regulatory agencies. What changes should clients be aware of?
Yeah, so we're still waiting for some of those changes to take place, waiting for some of the political appointees to get in place. But one of the areas we're looking at specifically is with the SEC. Paul Atkins was recently confirmed as the chair of the SEC, and he's taken the approach, just like what we've seen from the Trump campaign and Trump administration, really around pulling back regulations, encouraging innovation, especially in the crypto space, and then also changing some of the enforcement provisions, doing less regulation by enforcement with the SEC.
And similarly, there are changes to the EOC and the NLRB, which are going to impact folks directly. They have let go several of the commissioners at the EEOC, which I think will both impact their ability to process any sort of claims that are filed and their choice about what they're going to pursue and enforce in terms of employment regulations.
Yeah, and I think even with those agencies, we'll still see the regional offices continue to be active despite the changes at the top of the agencies, and certainly the expectation is that they'll follow closely the directives of the administration, right, especially on the DEI front.
Agreed.
Are there specific policy areas where we're already seeing an impact of the administration's approach to relaxed regulation and enforcement strategy?
Yeah, there's really no shortage at this point. Some of the highlights that we've seen the administration take a number of non-enforcement stances, specifically with respect to the SEC climate rule. We've seen the same non-enforcement provision with some of the other rules around the Corporate Transparency Act, which would have required more reporting and disclosure by a lot of different companies. We've also seen non-enforcement with the Foreign Corrupt Practices Act, and we've seen the dismissal of a lot of enforcement cases, especially again with the SEC with crypto companies.
Clearly, there's a lot happening already. What are some of the things you're keeping an eye on going forward?
Yeah, so there's a number of different things we're looking at. I think one of them that is front of mind right now is around the SEC cyber disclosure rules that came into effect in 2024. Whether the SEC is going to take a non-enforcement position with respect to those, or if they're going to try to completely pull those back, repeal those in some way. Another area we're keeping an eye on is around AI. There was an executive order loosening some of the standards with respect to AI, and to see what the ramifications of that are going to be. We're looking in the cannabis space. The Biden administration started a process looking at descheduling or rescheduling cannabis. There's also been some legislation around it. Trump seems to be in favor of that, but some of the appointees maybe are opposed to it, so we're watching that pretty closely. And then really the legislative front is the big question right now. So far we've seen a lot of action administratively, but we've got to remember anything that this administration can do, non-enforcement provision or otherwise, a future administration could change that approach unless Congress acts. Right now they're focused on tax reform, but after that, the question is, what are they going to pursue to try to put in law or take out of law so that a future administration has their hands tied?
So, Andrea, turning it over to you for a minute, what are some of the immediate impacts of these changes that Scott has just talked about?
Well, I think first and foremost, there's a lot of uncertainty and a lot of trying to figure out how to respond. I mean, Scott, you probably have more insight than I do on what goes into legislative changes. There's a lot of proposals and debate and public commentary. So companies have time to sort of get an understanding and figure out how they're going to respond. When executive orders are just issued by the administration, it's tough. You don't have time to really evaluate and anticipate and determine how you're going to respond for regulatory compliance. And again, I think we talked about some of these examples in the DEI executive orders and how companies have kind of scrambled to figure out, how are we going to keep our employees comfortable that we have a very inclusive environment and we're non-discriminatory, but also comply with the regulatory framework. So I think we're seeing, there are companies that are taking down information on the websites while also trying to reassure their folks that they're working within a very inclusive community. Another thing that we've seen a lot of very recently is trouble for companies issuing financial guidance. Now, guidance is not required. You don't have to issue it. But if you do, and you do something or say something that is ultimately wrong or misleading, that's when a lot of securities cases can emerge. So, companies are very careful about it. And I think with the tariff issue, that is leading us to a situation where companies are either withdrawing guidance, or they're not issuing guidance at all, or they're providing multiple scenarios. Like, if the tariffs are in place, we'll do this, it'll look like this, and if the tariffs aren't in place, it'll look like this, which is just difficult to juggle and come out with one coherent direction.
Absolutely. And this is really a question for both of you. Scott, I think I'll turn it to you first, though. But how does less federal regulation and enforcement impact risks for businesses, and will others fill the void?
Yeah, so I think it's a really important question. I think what we've seen historically is that conventional wisdom is that less regulation, less enforcement is good for business, and that might be true. But there's a few things to watch out for, and to answer the filling the void question is, historically we've seen states try to fill that void and private litigants trying to fill that void, especially with respect to states that are the opposite party as the president's party. So in this case, blue states maybe taking a more aggressive approach with their regulation as well as their enforcement provisions. And then with respect to private litigants, the uncertainty that you talked about, Andrea, I think creates an opportunity for plaintiffs' lawyers to second guess companies.
Oh. Yeah, absolutely. And just some of the state issues that we're talking about, you talked about the SEC, pulling back on their climate disclosure rules. But bear in mind that the European Union has their own climate disclosure rules, as does California, which is a big financial operation in the United States. So to comply with California, you're probably going to meet a lot of those standards that were already in the SEC guidance. And as you say, we're expecting a lot of legislation from states regarding AI and probably activity on the employment front as well. In terms of civil litigation, there's been quite a bit in the media about law firms that have very robust white-collar defense practices who are concerned about the viability of those practices, because if the government is not continuously investigating and enforcing these regulations, it can impact the law firm's business. So there definitely is concern and feeling that is likely going to happen. And the question is whether there's going to be private firms and private plaintiffs that are going to come in and fill that void. And, it's very lucrative for them on the security side to do so. We do expect there's a big incentive for them to step up and do that. The EEOC, we also expect, a lot of private plaintiffs to step up and pursue private actions. It's interesting. I know there's been a gutting of a lot of the commissioners and personnel at these federal agencies. So I don't know if that's going to impact private plaintiffs' ability to get private right to sue letters, if they're going to be able to get them that quickly. But I would expect, since private plaintiffs still have the ability to sue under both disparate impact as well as traditional cases, that they're probably going to take the opportunity to do that, because the EEOC is probably going to stand back.
Keeping the spotlight on you for a minute,
Okay.
Andrea, and tying this back into insurance, what we do, and specifically D&O insurance coverage, do we expect to see a reduction in claims frequency and severity based on everything you both have already talked about today?
I think we will see a decrease in claims activity. I'm not certain about the severity that could go up. And the question is just how big will that drop be, right? Like, we know and we expect that the government's investigations will not be as robust as they have been in the past. And since many of the private claims were sort of tag-alongs to that, so as the government would conduct an SEC investigation, plaintiff service would come in and say, oh, yes, us too, we want to tag along. So those won't exist, but again, private firms are still very incentivized to sort of step in and say, well, if the SEC is not going to regulate, we can come in and do it ourselves. I think the volatility in the stock market due to the tariff, changing tariff positions, is going to lead to quite a bit of claims activity, because stock drops always do. And I think, there's also this theory that if there is less regulation by the government, if these acts like the Foreign Corrupt Practices Act, which dictates, penalties for bribing foreign officials, if the government's not going to pursue that, then it's probably maybe going to go on. So does that give private firms the ability to go to pursue claims?
And how are underwriters reacting to these regulatory changes?
I think probably they're they're as confused as the rest of us are in some cases. They definitely are interested in strategies that are undertaken by the companies to address their regulatory compliance obligations. We've seen very specific questions from carriers as to how companies are dealing with these DEI executive orders, what their go-forward strategy is to address these, and how they communicated, as I mentioned before, the balance between reassuring employees, but also complying with your regulatory obligations. They're also asking about overall relationships with regulators and key financial operational objectives and guidance, as we mentioned, financial guidance for 2025. and how the new administration and the current inflationary and economic slowdown might impact operations. And that's where we get into these multiple guidance scenarios where we'll tell you how we're doing depending on what is going on politically.
Yeah, to me that sounds incredibly fascinating. I think, as more and more information comes out, I mean, we're only just over 100 days into the administration. Things are going to continue to change and evolve, and so I'll be interested to hearing more about how the underwriters continue to change the questions they're asking.
Yep.
Yeah.
So we've kind of covered a lot. We've covered the regulatory change piece, we've covered the insurance angle, so now kind of turning to recommendations for our clients. Scott, how can businesses manage rapid regulatory change?
Well, it is certainly rapid right now, and that makes it particularly difficult to keep your arms around things, to try to understand things. I think the best way certainly is to work with their lobbyists, whether they're in-house lobbyists or outside lobbyists, be able to work with them on a regular basis and have lines into the C-suite especially. Whether you've got lobbyists or not, a lot of companies are part of trade associations who do have lobbyists and are working on these issues, and so staying close with them and making sure that those trade associations know and understand the issues that the company is dealing with. We'll certainly try to keep clients updated on some of the changes and some of the impacts, some of the changes that we're seeing with the underwriters as well. But it is certainly a lot to keep track of right now.
Agreed. So Andrea, putting severity aside, if claims fall in frequency, we know there's still going to be some claims as we discussed. What help should companies expect from their insurance brokers, and what should companies be looking for when building their D&O program?
Well, I have a couple recommendations that are probably exist even outside of this that are very important, but I think are particularly important given the climate that we're in right now. Is first, you want to choose a broker that's fully conversant in the rapidly evolving and changing regulatory environment. I think companies want to develop a strategy, often with the use of outside counsel, to address regulatory compliance efforts, to make determinations on what your strategy is to comply. And you want to ensure you're working closely with your broker to present the best possible risk profile to the market, to tell the best story and demonstrate how you are complying regulatorily. We want to confirm there's broad coverage grants in your D&O policy, and we want to particularly look at the exclusions, both which are potentially impacting regulatory claims and actually claims that could be brought in lieu of regulatory claims. We want to make sure there's no language that's going to be problematic. And we want to consider the claims handling, as always, and the claims paying reputation of carriers on your entire program to ensure that they're going to respond when you need them to respond.
Thank you both for such an enlightening conversation today. Thank you all for joining us. For more insights from Locked In, subscribe to our YouTube channel, follow us on LinkedIn, and visit our website, lockedin.com.